Okay, I'm seeing that it is, according to my watch, 6:30. I may still wait another moment. If you could be patient, just give me a minute or so, in case there's anybody coming in late, that we can sign on, and then I will get right to it. I won't wait long because I don't want those that got here on time to be here any longer than you need to be, but I'd rather as many people get the information as possible, so I'll give it another minute. All right, I think that's long enough. Let's just jump right into it. Once again, before I get into it, somebody type into the right quarter panel in the questions if you can see the PowerPoint and hear my voice. Anybody? Okay, so I'm not seeing anybody, which causes me to be concerned that the audio is working. I need somebody to type into the right side on your quarter panel on the bottom where it says questions. Just type into one of the white rectangular boxes that you can see and hear. You can see the PowerPoint and that you hear my voice. Okay, looks like we're good to go. All right, so thank you for your patience and welcome to the Micklin Law Group's monthly webinar series. We do a webinar once a month, usually the last Thursday of every month, depending on the holiday schedule and possibly my schedule. Tonight's webinar is the hard truths behind men's rights, divorce, and complex custody issues. Without much ado, let's get into what you can expect from tonight's webinar. If this is maybe your first time attending one of these, the webinar is a one-way communication. So as you probably noticed, you should be able to see and hear me. I cannot see or hear you. You also should not be able to see the others that have registered, so everything about your attendance here is confidential. I schedule these for 60 minutes, but I really take as much time as it takes me to get through it. I try to keep as close to the time as I can. I know everybody's time is valuable, so I do what I can to rush if I'm behind. And then I take questions at the end. I'd like everybody to save their questions until the end so I can address them all at one time, not interrupt the flow of the information. But I'd recommend that you type them into the question box in your control panel on the right side of your screen. It should be on the right side. Whenever it comes to you, so that it'll be there at the end when we get to it, and make sure not to miss your questions. And I'll stay as long as it takes to answer any questions that you have, so you don't need to worry about time. If for some reason we don't get to them or you need to go, you can always email me at brad@micklinlawgroup.com, which you should have from these invitations. Real quick, the purpose of these webinars in general is I wanted to create a library of information or resources where our clients and potential clients could go to get information about their cases, because I found over the years it's almost impossible to give clients all the information that they need about any one given topic, let alone all of the topics. So instead of having to come to me with broad questions or sometimes not even knowing what to ask me, I started to create these so that you have a wealth of information. So as you go through a case like a divorce, for instance, instead of having to come to me for your case information statement questions, I did a webinar on case information statements so that you can watch that and have a better sense of what to ask me. Did one on domestic violence. So if you're going to file for domestic violence, you don't need to call me with questions. You can go there and research it, and then you're better prepared to speak to me about it afterwards. But of course, as you know, those that are working with me, some of you that are signed on today are working with me. I hope you know that my door is always open for any questions. It's not that I don't want to answer questions. I just want to provide the most economic and fast way for clients and non-clients to get the information they need. So for those that don't know me, this is me. No, it's actually an older picture of me, but it's me, not much different. My name is Brad Micklin. I'm the managing member of the Micklin Law Group. I'm a member of the New Jersey State Bar, licensed in both state and federal courts. I started my practice about 25 years ago in a clerkship with Judge Eugene Austin in Bergen County. He's actually since then retired or is just about to retire. From there, I went to Kessler & Associates and did complex commercial litigation for a number of years. found that while I liked the complex litigation, I didn't care much for representing businesses. I really liked, dealing with people and kind of being in the heart of matters. So I gave that up and I opened my own practice in 2001. At the time I opened, I was a general practice attorney, which means I did a little bit of everything. And then I quickly concentrated my practice into divorce, custody, and family law issues, which is what the Micklin Law Group is today. Next, some of the recent awards that I've been honored to receive. It's actually a little outdated. I've been meaning to update this. I have some more recent ones, but the ones on the right are the more recent ones, and then they kind of progress, or the left, and then progress to the right to older. Many of them I've received multiple years in a row, and I just have the 1 year representative occur. And this isn't here for me to boast or to feel good about myself, but it's really for those that are either working with me or attending this for the first time to really know that there's credibility behind what I do, that I care a great deal about what I do, and I try to do it as best I possibly can. So you can trust into the advice that I'm giving you, both here and while we work together. So let's move real quickly into what we're going to cover. I'm going to just move through these quickly. We're going to cover divorce, issues specific to men and issues that come up that men face, domestic violence, custody, and child support. I want to make a quick comment too, because as many of you on the webinar may realize, my firm is starting to concentrate more into men's rights and the challenges that they face. Doesn't mean we don't represent women. We certainly represent women. The knowledge of what issues men face help women to know that equally as well. So it's not like we favor one over the other. It's just a greater concentration to provide better service, but it ultimately will help all people through the process. So let's talk about divorce. And one of the most important topics and most troubling for most people, the alimony and the recent amendments to the alimony statute. I think maybe it's 3 years ago by now, they've made many changes to the alimony statute. The intention was to codify the things that had been in practice in courts and with lawyers and judges over the years that didn't really match with what the law said. I don't know whether or not they really achieved that. I have a personal different view, but let's go through some of the changes first. First, they removed the word permanent. And the reason was because permanent was not really permanent. Permanent would last up until a retirement age or a material and substantial change of circumstances, the two most common reasons, among many others, why permanent alimony would stop or be modified. So instead they took it out and they called it open durational. Now, I don't even think durational is an actual word, which says a lot about our legislature, but now it's open durational, and there are different changes and reasons for modification that change signifies. So for instance, the law now says if your marriage is less than 20 years, alimony cannot be longer than the term of your marriage. The reason was there was an ambiguity of when could permanent alimony be issued. There was even a case that said even after 1 year, it might be appropriate for permanent alimony to be issued. So nobody really knew. It was hard to advise people. And it started to become a practice where if you were married 15 years, people would think it's permanent alimony, but not every judge would. But 20 years, everybody would think it was. And it just became difficult to advise anybody because you never knew what one judge from another would say. So they tried to create a bright line and say the 20-year mark. The thing about it, this hasn't been addressed yet, but it's an issue I think is going to come up soon. So the statute technically says if your marriage is not longer than 20 years, the term of your alimony cannot be longer than the marriage. And that sounds like a good start. What it doesn't actually say is if it's over 20 years, that it can be longer. Now, I think everybody's assuming that that's implicit in that, but my belief is if it were going to be intended, it would have been written. It's much easier to simply write that than to pretend it was intended. So it's going to be an issue for those over 20 years because I believe everybody is still considering that 20 years is an open durational alimony term, and I don't necessarily think it is. Next, they define cohabitation. It used to be not in the statute, but that was one reason you could modify alimonies if there's cohabitation. And an issue started to arise where people would have an agreement that says alimony terminates, and they list the reasons that exist in the statute, but they wouldn't say cohabitation because the case law said cohabitation. So people would rely on the fact that the law said cohabitation, but their agreements didn't say it. And there started to come down cases that said, well, that's a conflict. If it's not in your agreement, it wasn't intended. So they decided to put it in for a reason, so it's defined. One interesting thing about it, which again I don't think has come up yet to the appellate division because it's a new statute, is, and I think it's a horrible provision that they put in the statute, but it says that alimony can be terminated if cohabitation is established. But if the cohabitation is ended subsequent to the termination, alimony can possibly then be reinstated, which I think is grossly unfair to the person paying alimony because it's usually a difficult burden to prove cohabitation in the first place. Not too many people go to their ex-spouse and say, I have a boyfriend or girlfriend now, you can stop paying me my alimony. They wait until you find out and you can prove it. And proving it's hard. So once you prove it, all the person needs to then say, hypothetically at least, is, okay, well, move out then because I got caught and I can get my alimony back. And there's nothing that prevents it yet. Another change they put in was to equalize for the paying spouse, which historically and still commonly is men. No offense to the ladies watching this. Men are still generally the larger class of people paying alimony. And the standard in alimony, or for alimony, used to be that you'd lead a comparable standard, comparable life marital standard. Now, not equal, but comparable. The problem became the focus was always on the lower earning spouse or the needy spouse to make sure that that person was leading a comparable life with no regard to the lifestyle of the person having to pay the alimony to maintain that standard. Now the statute says neither party is entitled to a greater standard of living, that they both are entitled to a comparable marital life standard. The reality of that is you never have a comparable lifestyle unless you're in a significantly high income bracket, because taking one house with one or two incomes and you break it into two houses with the same incomes, things are going to be changing. It's not going to be comparable. But at least now they're forced to look at both parties. Change of circumstances was revised. It used to be if you had an alimony or child support obligation and you lost your job or had a change of circumstances, disability, whatever it may be, that you had to wait 6 months before you could file for a change of circumstances. The theory was the change would be considered permanent, and only after 6 months do we realize it's more likely, or temporary, and after 6 months it's more likely to be permanent. Well, that was grossly unfair to people paying alimony, because what happens is obviously most of the time you're not making any money or you're making less money, and if you have to live that way for 6 months, you're in arrears. You could have your driver's license suspended, your passport revoked, which we'll get to later, because you had to wait so long, and now you're under the gun and you're in arrears and it was hard to get relief. It was just brutal for people that needed to modify their support. So they changed it and made it only 3 months. Not that that's much better, but it's at least understandable why they'd want you to wait a period of time. I still think 3 months is a long time to have to wait before you can even go to court and ask for relief. They added a lot of provisions about those that are self-employed, especially when it comes time for either modifications or for retirement. I'm not going to go into it at length because it's going to be too cumbersome for this. But again, more often than not, men are self-employed when they're paying alimony. There's now new standards about what kind of documents you need to provide and what kind of proofs. And the reason is because it's believed that a lot of self-employed individuals have ways of manipulating their income. They also have different forms of income, even absent manipulation, that may not actually be captured on a tax return or a pay stub, but that they're receiving the benefit of. So they tried to make sure there was a more balanced approach to analyzing income for those that are self-employed. And it changed a lot of provisions about retirement. And it was probably one of the best changes they made, I think, because in the past retirement was considered a change of circumstances. So you would have a basis to seek a modification of what was then permanent alimony more often than not. The problem was you had to take the actual retirement before you had a change of circumstances. So if you retired and changed and you filed a motion to modify and it's denied, now you're without a job and under the same alimony obligation. But if you didn't retire and you filed and said, I want to retire, they'd say, well, it's speculative. You can't get a change of circumstance because it hasn't happened. Now they allowed for anticipatory retirement, meaning you can file a motion saying, I'm planning to retire, I would like to retire, but I can't because of this alimony obligation, it should be reviewed. And more common than not, it will likely lead to a review, depending on what your agreements provide for, if you have an agreement that predates the alimony statute modification. More on the alimony factors. I'm going to try to move a little bit quickly through these. First is need and ability of parties to pay. It's one of the most important provisions. What's important to know here is that there is imputed income analysis. If you are underemployed or unemployed, whether you're going to be paying or receiving, and you're not earning what you should be or could be, the court will inflate your income for support purposes. So they're going to determine need and ability based on the actual ability, not on your actual earnings. Duration of the marriage is one of the, these two are one of the, I think, top 3 or 4 reasons or factors they look at for alimony. Duration of the marriage will determine the duration of your alimony. I always look at like short, moderate, long term. So short is going to be anywhere up to like 7 years-ish. Moderate's going to be around the 10 to 15 range, maybe below. And then long term is going to be 15 to 20. And your alimony is going to be kind of commensurate with that period. So if you have short-term marriage, you have short-term alimony, middle, and then long. A gauge that a lot of us use is a term of alimony is generally going to be anywhere from 50 to 75% of the length of your marriage. Now, again, there's no bright line rule to it, and it doesn't necessarily mean it's accurate, but it's one of the things that many of us use because it's a lot easier than trying to figure out under the full alimony statute, which has like 14 or 15 different criteria. But it's important to remember that while you'll be told this by lawyers and judges alone, doesn't mean it's accurate. That if you are not willing to pay alimony for 50 to 75% of the term of your marriage, you have to insist that we actually go through the analysis to see whether or not it's warranted, because a lot of things change in the time frame of an alimony where it's not contemplated at the time that people are agreeing to it. So that's something I really think is important to take from this information, is that you do have the right to require an in-depth analysis of your duration and not just bright line rules that we use as practice. Age, physical, and emotional health of the parties. Truthfully, never really seen this used unless there's maybe a disability or a serious kind of impairment that keeps one party from being able to fully earn. Usually you'll need an expert medical or work-related occupational to determine whether or not the disability or impairment does really affect alimony or not. Standard of living established during the marriage is one of the more important. So I think let me get my little fancy pen out here. I think the ones that are most important that they're looking at is need and ability to pay, duration. Standard of living is also very significant. They're going to look to see the comparable standard like I discussed. That is an important one to analyze. And I won't go through what you need to do for that. That's actually part of the case information webinar, the case information statement webinar I did. But it's very important to really establish what the standard of living was to make sure that your alimony obligation is going to be fairly set. It's not just a number crunch. You know, sometimes you had family gifts that are or are not included. Sometimes you lived off credit cards, and that doesn't necessarily mean the judge is going to say you don't have to do that any longer. So it's very important when you're preparing a divorce that if you're going to be paying alimony, even if you're going to be receiving it, to dive deeply in the beginning of your case into what the standard of living was like. Next, earning capabilities, educational. This is utilized. It's not the significant one. I think it's kind of implicit in the need and ability to pay. Your educational and experience is going to be what they use to determine your ability to pay and your need. Parental responsibility for the children. Rarely have I ever seen this be specifically addressed, other than the fact when you have very young children, sometimes the cost of daycare can outweigh the potential alimony or even the numbers that are involved. So parental responsibilities to that extent will influence it. Other than that, I've really rarely seen it affect alimony calculation really in any way. So let's look at some additional terms. So like I said, there's like 14 or 15. Time and expense necessary to acquire sufficient education. This is important. It's not necessarily when it's considered an awarding one, but it's usually considered when you're trying to resolve your own and setting a term. There's many types of alimony, which I won't go into. I also did a webinar on that. But alimony can be terminated or modified for different reasons. So each type that you may agree to will have a different reason to be modified. When you make a plan, if you're coming to an agreement, you want to look at what the lower earning spouse's plan is going to be. Are they going to go back and seek a new profession? Are they going to go and finish a degree or acquire a skill? You may adapt your alimony award or agreement to fit that time frame. Sometimes you want to pay more so that they're able to finish a program and be independent or be a higher earning faster. Sometimes it's better to front load payments to get out of them earlier. History of financial and non-financial contributions. Again, not a big factor. More often than non-financial contributions are looked at, and that's usually parental responsibilities, raising children. I think that's the reason it's there, so that they could justify why somebody who may have not contributed to the finances, the actual dollars or investments, would then be entitled to comparable lifestyle and support. So I think it just goes into the underlying philosophy for having alimony, but it's generally not a factor that gets weighed heavily. Contribution to education, children, personal careers. Again, it goes to what I was saying, that if you left a career to raise your children and such, that would be why they would take into. Now, another thing that they added under the new statute is, I'm sorry, not this one, equitable distribution of property ordered and payouts of future income. This I rarely see affect. Now, it only comes usually into play in your higher income cases where there's going to be asset income, passive income that gets generated that may actually have an effect on the needs and lifestyle, but not very common. So the next one is what was added in the new statute: nature, amount, and length of pene lege support, which is your temporary support ordered throughout the divorce. Prior to the amendments, it was not considered. So if you had a 5-year marriage and a 3-year divorce, you could still have a 5-year alimony, and it'd be 8, because the 3 that was before or during your divorce didn't matter. Now it can be considered. Doesn't necessarily mean it's supposed to be subtracted, day for day or year for year, but at least it's now something that should be considered. And last, as we always see, regretfully or something positively, any other factors deemed relevant by the court, which basically means the courts can do and look at almost anything they want. Now, let's talk about modification. And there's a webinar I also did on property settlement agreements, which I would recommend that you watch, because when we talk about modification, a lot of this is going to be things that you should build into your settlement agreement. But I'm going to kind of just move through these because I'm, I think, greatly behind my schedule. Not behind, but I'm taking a lot longer than I anticipated. Anti-lepus clauses, that is something that goes in that says, basically, it's named after a case, Lepus versus Lepus, talks about whether or not you can maintain the marital lifestyle, and whether or not you need to say that you are or are not going to be able to maintain it is something that's dictated by this. It's usually a no modification clause, meaning that you're putting an anti-lepus saying that you cannot modify in the future. And that cuts both ways. If you're paying or receiving, on the one hand, you want to say it can be modified because you don't want to end up paying more in the future. But if your circumstances change and you lose your job, you now can't modify because you agreed for the same modification. So it's tricky. In my opinion and in my experience, a substantial change in circumstances still will override an anti-lepus clause because of the equity powers of the family court, but you still need to consider it when you're writing it. Permanent versus temporary. Well, again, it's not really necessarily permanent, but temporary is whether or not your change is permanent. Again, under the new statute, it's now 3 months, but it doesn't mean it's just a time frame. You do still need to establish that it's going to be temporary or permanent. You have an obligation to obtain comparable employment, so you need to show, if you're looking for modification, that you made every effort. And now with the use of the internet for job searches, it's sort of easy and hard to apply for jobs because you can push a button and apply to 50, but it's hard to document that you actually did that. So you need to have documentation, and you should be sending out every single day. If you think you're going to be modifying for a loss of employment, you need to show that you searched high and low everywhere you could before filing, so that they know that you used your best attempts to get comparable income, or they won't even consider modification. Imputation of income, talked about that already in the beginning. If it wasn't clear, just email me. I'll go through that again for you later. Now, see, like I was saying, the new statute is intended to get more clarity and uniformity for judges in their decisions. Whether or not that's really going to happen is still kind of up in the air. It's still a relatively new statute, and there hasn't been a lot of appellate decisions to really dive into if it's working or not. My opinion is most of the changes weren't really necessary, and the problem really is that the practice and the utilization by the judges is what needed to be corrected, or what needed to be corrected. I don't think the statute needs to be changed or needed to be changed. I think judges needed to use it the way it was intended to, and they don't. But that's my high horse. So let's go in a little bit more about modification. As I said, cohabitation was codified and defined. It used to be something just by case law. Now it's in the statute. Other children, other dependent deductions. If you have another child, whether or not there's a court order to support, you are entitled to seek a modification. That is generally considered a change in circumstance. You can do it if there's a change in yours or your children's needs. A lot of special needs children, a lot of changes in education. A child that's going to college doesn't usually, if you're going to college, that's usually not a change of circumstances because that's a voluntary choice on your part. But if you have a child that's going into college, obviously the finances, it's just a greater support obligation, like having another child that gives you the credit. Remarriage can be a reason. If you're paying, that you could argue the person receiving your alimony payment that has remarried could be reason to modify. Your own remarriage is not likely to be that way because all you're doing is bringing another income into your house or another potential income. So it only works to the person that you're paying it to. Non-self-employed versus self-employed. Again, I touched on that. I won't take more time now, just to know that the reasons and the proofs necessary to document are different now, and they're specified under the statute. But also, if you are employed and you go into self-employment, that will not likely be a change of circumstance because just like college, it's a voluntary choice, and they're going to impute income if you're not making that. Temporary and pending-related remedies, I'm going to skip over this because I think we get into this later, into what kind of enforcement powers they have. And then one more thing about the retirement that I didn't mention before. I mentioned before how they allow for anticipatory retirement, but now there's a presumption of retirement at 67, but there's also a provision in the statute that allows for you to retire at whatever age would be common in your profession. You know, for instance, police officers usually have, I think it's 25 in, they can retire. So, you know, if you happen to join the force or the army in your 20s, you know, you're coming out sometimes in your late 40s, early 50s. So you might still be able to retire and modify your alimony because it's common in your profession. Again, I hate to sound like a broken record, but these things haven't really been established yet because the statute is new. So that's why I think it's important for you to realize these issues now. And even if you can, address them into your support agreement, assuming you're not going to a trial. All right, so now let's move into pending support awards. Now I'm going to say a couple things that may make the women that are attending this or watching in the future get insulted, but I think there is a bias that women do receive temporary support and alimony more than men. I have yet to see a man who's earning less than his wife get temporary support payments during a case. But I have seen many women who are working but earning less than their husband get temporary support. I've also seen men that are making not substantially less than their wives not get alimony, but in the reverse, I've seen that. So when I say that, it's really based on my 25 years of seeing that men have a very difficult time getting alimony, both temporary and permanent. And they walk into a lot of problems, like whenever there's a drop of income, they automatically say, well, it's divorce planning. Rarely will you have a judge accuse a woman of divorce planning because she's not making as much money as she used to be, or her business is going down. So you really need to keep records if you are self-employed or you change your job. Like I said before about your job search, if you're self-employed, you got to keep very good business records and bank records. For those that are self-employed, I recommend that you get and keep at least 5 years so you can show that there's been a trend. Most businesses don't collapse overnight, although some do. But there's usually going to be a trend, and you need to be able to document that trend easily. Now, when you're talking about Pudendum late support, the most important part of that is going to be the case information statement. And I can't say it enough to watch the webinar I did on that separately, because it really goes through detail. This is the most important document in your divorce case, especially if you're going to be paying alimony. And again, this webinar is really intended to those that are likely to be paying alimony. So first is there's a joint individual column. This is important because a lot of people skip this. I don't know if they don't see it. It's difficult. The document itself is very challenging. Actually, I'm sorry. It's not joint and individual. It's joint and current. But the individual is because it's current. Usually you're separated. The joint is your marital standard. So they both need to be accurate because they're going to determine what is the lifestyle and what are the needs, quite simply. It's important to document what you have in your case information statement because it's going to be used for the entire case. So if you put that your electric bill is $300 a month, you should have several electric bills ready. You may even want to attach them to it. It sets the tone for litigation, in my opinion. The Pudendum later word, not the case information statement. Because if you are paying too much, you're financially strapped and you're pressured to settle. And if you're receiving too much, or if you're not receiving enough, you're stressed and in need of money and you're desperate to settle. Similarly, if you're getting too much, you have no incentive to settle. And if you're paying too little, you have no incentive to settle. So the wrong Pudendum later word can really upset the tone and future of your litigation. Review your spouses critically. Make sure that everything adds up. Make sure that you can document wherever you think there is a change. Don't nitpick on things like gifts, but look at the car payment. Look at the insurance. Look at what's going to happen in the future. Is there a daycare expense right now that's not going to be there? Is the car going to be paid off in a year and that payment gone? Very important if you're going to be paying support is to look at your spouse's CIS critically. Make sure yours is accurate, of course. One, for credibility purposes. Two, because you're going to be, no pun intended, married to this as you go through if you say this was a lifestyle. A lot of people will decrease their lifestyle expenses and increase their current ones because they think, well, if they increase their expenses, it'll show they have no money. If they decrease the marital life, it'll show there was no fancy lifestyle. Both are wrong. Both hurt your credibility, and both have the courts wonder and say, well, where's all the extra money then? You're paying all these bills, where's the extra money? You have to update it at least 20 days before trial, but you should periodically through a divorce. Your average divorce will last 12 to 18 months, if not longer. You might want to do it every couple months. Even if it's not being filed, just update it yourself. But one thing to remember, it's a summary document. So I tell my clients, as important as it is, don't go crazy over it. You know, we're not going to expect to know exactly how much you spend on your haircuts every single month, but you need to have some sense of the general expenses. Either go by a month or go by a year and break it down. It does need to be accurate, but it's a summary document, so don't go and get paralyzed in completing it because you need it. More on Pudendum Lite awards. The intention is to preserve the status quo. It's usually a higher award than a final alimony will be because the status quo is maintaining the household. It usually does not impute income. It doesn't look at future consequences. It looks to keep everybody as close to being intact as they can. They don't want the low earning spouse to have to move out of the house and on the street because there's no, the mortgage isn't being paid. It's often much higher than it should be. It's often very difficult for the paying spouse to manage. And that's why preparation is important. It's going to be very high if you're a stay-at-home parent. Obviously, because of status quo, there's no imputation of income or inflation of income. They're going to be looking to make that person as comfortable or as close to as comfortable as they were before. The problem with it, it's usually ordered before the exchange of financial information. So the court's really going on just the case information statement and what each person is saying the lifestyle was, and it's usually not very accurate. Now, you'll be told that there's something called Malamo, which is a case that allows for retroactive modification, which means if the court sets it too high or too low, at the end they can go back and modify it, which first doesn't help you at all anyway, because you don't need the help at 18 months later at the end of your case. You need the help right now. If you can't make the payments now, it's not going to help you to modify. Second, more importantly, I've never seen it utilized. I've been doing this 25 years. I know the judge that ruled on the case. I've been before him many times. I've done thousands of divorces. I've never seen it ruled by a judge. I've never seen agreed to by a party. So don't count on getting any retroactive modification. But also remember, just because it hasn't happened doesn't mean it can't happen. If you are grossly overpaying, it's something you're allowed to ask for. But don't let people convince you that you're going to get it. So they say, don't worry about the payments you're making now. Worry about them now. Tax allocation, very important. There's a conflict I've run into where the IRS guidelines say that if there's unallocated support, it's all tax deductible. Judges say when it's unallocated that it's not tax deductible. I've run into the wall, so you want to make sure to allocate it when you're getting an order for support, or if you're agreeing to temporary support. Either agree that how much is going to be allocated for alimony, which is tax deductible, and how much will be child support, or at least agree that you will later reserve the right to allocate it, so that you may not get the actual allocation, but you have the right to allocate it. And seek advice of accountant, especially when you're talking about perennialities, not only for the allocation, but to file taxes. You may be married and paying temporary support at the end of a tax year and still not be divorced. It might be better to file joint. It might be better and not take the alimony deduction. It might be better to file separate and get an alimony deduction. So you really need some good accounting advice when the end of the year comes and you're still married. Now, the next area that is often important to, and it's important to women too, but from the standpoint of this, is domestic violence and temporary restraining orders. A restraining order is a temporary restraining order, very easy to get. I often, and I mean no disrespect to the victims of domestic violence, I've been schooled in this area since law school. I've been studying and working with it all the time. But I often say it's like giving out candy on Halloween. There's very little that a person has to say to get a temporary restraining order. It's often going to be granted by a municipal court judge, can be by family court if it's during the day, but most of the time, in my experience, it's at night, weekends, and holidays. You go to a municipal court judge. There's one on call 24 hours a day. They're very easy to get. The mentality, or the belief I should say, is that it's better to err on the side of caution than to leave somebody subject to greater violence. And I don't necessarily disagree with that, but sometimes I've seen them where it was clear on its face it should not have been granted. I do think they need to start adjusting it a little more and scrutinizing them just a little better. Criminal complaint is separate. A lot of people misunderstand that. Sometimes it's automatically issued, but it's a different court. It's a different type of court system. It's even on a different color paper. So you have to keep notice, because sometimes they get scheduled on the same day and people aren't aware of that and they're in the wrong court, and it causes problems, causes severe problems. So let's look at what are the reasons you can get a predicate act. I'm going to put these up here first. The predicate acts are any criminal act, basically. It matches and mirrors the criminal statute. So it itemizes several of them. I'm going to put them up here so it helps us move a little longer, give you a little talk about some of them, and my mistake, and how they come into effect here. So obviously here we have assault, harassment, terroristic threats, and stalking. The most common assault is any strike or offensive touching. Harassment is an act, and I'm simplifying these, so bear with me. Harassment is any act that is committed with the intent to harass or at inconvenient hours, which is a very odd phrase, but it's a very light threshold to prove. It's very easy to establish harassment. Terroristic threats has to be something more than just a mere threat. The terroristic intention, you have to intend to terrorize the person. Stalking, which is, I'm not going to go into the actual definition. I think most of us have some idea what stalking is. I believe there's even some cases now that putting a cell phone or a GPS tracker in somebody's bag or car is also a form of stalking. So be careful. A lot of people do this in the early stage of marital contempts or contretempts, but don't do it. Homicide, obviously, sexual assault, kidnapping, criminal restraint. Now, criminal restraint is important because a lot of people won't realize that this has been committed. And if you are the victim of domestic violence, criminal restraint can be anything like locking the door, blocking the driveway. It goes around with false imprisonment. It's slightly different. It's more severe. But they both should be considered if you are the one filling it out and seeking one. Criminal sexual conduct, criminal mischief, excuse me, is one that is often overlooked. analogize that to like breaking of the cell phone, smashing telephone. It can be the reason to seek a restraining order. Burglary and criminal trespass. The reason I explain these is, again, more often than not, men are the defendants in the domestic violence. And in a lot of cases, not all of them, but some cases, they're not necessarily a genuine case. My advice generally is, if you've been on the opposite side of the attack, often a violent situation will have violence on both sides, sometimes offensive and defensive. But if you've been accused of domestic violence and you have a basis for it, I usually recommend that you file a cross complaint. And you can usually look to things like false imprisonment, criminal mischief, even in the past, as grounds to seek that. It does help balance the playing field. So now you're both defending on a restraining order. It usually gives you much greater leverage to try to resolve it through maybe a civil order or dismissal, as well as giving incentive to step away from it and resolve it, because now you both stand to possibly lose. So if you are ever on the defendant side of a restraining order, you do want to consider this. You should familiarize yourself with the basis that you can seek a restraining order. Important points about domestic violence. Prior history is only important if an act has been proven to be committed on the day the allegation was made. So they could allege you're the worst person in the world, but the court can't look at that unless you or that person has committed an act. So be very careful to document a prior history or an inaccurate prior history. But if you are defending, and even if you're prosecuting, but if you're defending, the more important focus needs to be on the act that was alleged to have occurred, not the history. There is a case, State versus Hoffman. It holds many things, but one thing it does say is that one act of harassment is sufficient to allow both a restraining order as well as the review of your history. Because if they can't prove the predicate act, the initial act of harassment, they can't even talk about the history, which you want to make sure does not happen, because the history can make it sound a lot worse. So if you want to keep it out by showing that a predicate act didn't occur, and State versus Hoffman makes that difficult, so you need to be aware of what that case says. One of the most common defenses is under a case Carenti versus Carenti, domestic contra-attempts, which basically means people fight. And judges recognize people fight. Just because you have a fight doesn't mean you've committed an act of domestic violence. It's a very common, very popular, very effective defense to a restraining order. A couple of things to know about the practicality of domestic violence is they will likely be adjourned numerous times. So while they'll tell you when you get served, you have a hearing date in 5 days, it doesn't usually go forward that time. And if there are lawyers involved and children, it may get adjourned several times. Very important to understand that, because you will likely, again, I'm speaking to the person who's going to be defended, you will be taken from the house. You may not have any contact with your children. You may be paying temporary support. You may even be taken away from your business if you work out of the home. Realize it could be many weeks before it actually gets resolved, so plan accordingly. And I say that because, in my opinion, a lot of people use domestic violence as a way to get some leverage in a case, or to get an unruly spouse or partner out of the house. I can understand that, but it's not what it's intended for. And like I said, because it can be so harmful and for such a long period of time, it's really something you need to be aware of. Now let's take a look at final restraining orders, what they do and what comes along with them. You generally want to do everything you can to avoid getting one. Don't be spiteful and say, I'll go to trial, and because you got the truth on your side. It's not about that. I won't go into what you need in a restraining order. I also, again, did do webinars on that. If you have this issue, I'd recommend you watch those. First thing about a final restraining order, it carries a presumption of full custody. So if your spouse or partner gets a restraining order against you, and many times they're using it for that purpose, or that's part of the motivation. Now, in my experience, a lot of judges are still reluctant to give full custody, but the restraining order law does suggest that it should be. So you need to realize, if you are in that circumstance, that is one of the outcomes you want to watch for. There's a central database. So you will be fingerprinted and put into the database, so that wherever you go, at least in New Jersey, any county, a police officer will punch in your name and will know that you have a restraining order against you. There are a number of restrictions. You will not be able to have firearms It will complicate your travel. A lot of times when you come back into the U.S., you may be detained because they want to make sure that the plaintiff, the victim of the domestic violence, is not in there, or that you weren't stalking that person. Sometimes it affects your job, it affects your ability to get new jobs because of the central registration. And then for certain professionals, it's really a problem, law enforcement, because you're not allowed to carry firearms. Although I did get a client one time permission to carry during the day, but it's unusual. Firemen sometimes are also lose their job because of healthcare professionals, anybody that's licensed, teachers. It can affect, if you're working with children. Lawyers, technically, I think it would be an ethical violation, could be problematic to your license. So you need to be aware that these are the outcomes before you step into the arena and make sure that you're well prepared for it. The next important issue for men in, I was going to say in divorce, but it's really inside divorces and outside custody. So let's talk a little bit about what you need to know and what's going to usually come up in your custody arrangements. Everything is going to be decided by best interest standard, what's in the child's best interest. The thing to remember here is just because the mother is alleging something doesn't mean it's in the child's best interest. And the important part is in the child's best interest. Like you'll get a relocation application and the basis is mom's getting a better job. Well, that's good for the child. It's not for the child's best interest. It's for the mother's best interest. So you really want to be able to split that hair and show that it's really not inuring to the child's best interest. It's just something for the mother. Legal and physical, very important distinctions. They will generally be joint, but legal is the important decisions. Physical is where the child is residing or staying from time to time. The major decisions versus day-to-day, if they're joint, major decisions will be made jointly. The day-to-day decisions still go with the parent of primary residence. Sole versus joint goes back to the legal and physical distinction. Sole is one parent makes all the decisions. Joint is it's supposed to be mutual, as well as physical custody is also supposed to be joint. Now, physical joint custody doesn't mean equal custody. So you'll almost always have joint custody, even if you have sole legal custody. And I often tell my clients, try to stay away, because there are a lot of terms, even in this short webinar, legal, physical, sole, joint, parent of primary residence. I generally tell clients, don't use terms, talk about what you want, and the rest of us will figure out what those terms are, because if you walk into court and you ask for the wrong thing, sometimes you look unreasonable. If you walk in and you say, I want sole custody or sole physical custody, you probably mean you want the child to live with you most of the time. You want to be the parent of primary residence, but you say sole custody, the judge thinks you want to take the other parent out of the child's life. So it kind of cuts against you. So stay away from the terms. There is a presumption, like I said, joint legal custody. The only reason why that's generally not going to be the case, and again, legal custody is the decision-making ability and power, is if you're found to be unfit. Very rare. You have to be so grossly incompetent and not capable of parenting your child that your parenting is likely to cause some type of damage or harm to your child. Very difficult, very limited basis to receive it. I'm glad to see there is a change. It used to be that mothers got primary custody, fathers got alternating weekends, alternating overnight weekends. The philosophy now is there's a presumption towards equal physical custody, meaning equal time. 1 week with you, 1 week with her, 2 days with you, 2 days with her, 3 and 4, but equal physical time. And that's a recent phenomenon, I'd say, over the last 5 or 8 years. Now it's a presumption, so it's very hard to combat it also if you are the mother trying to resist that. Parent of primary responsibility during the marriage usually will lend some credibility to an argument if there should be an unequal physical time or a parent of primary residence. Usually it's the caregiver during the length of the marriage, but again, doesn't really override the equal presumption that's been creeping into our system now. Lastly, like I touched on, basically, there's a PPR and a PAR designation. There's parent of primary residence versus parent of alternate residence. That doesn't mean anything about the time sharing. It just means one has slightly more, may even be in equal. You still need the PPR designation because that's usually what you need to register a child with school. So the distinction is becoming less and less relevant as the physical time that's being shared is becoming more and more equal. Next, let's talk quickly. I'm sorry, I'm getting a very sore throat. Some of the issues that you will face in custody issues, both during and after you separate, whether you're in or out of a divorce. The main one is going to be relocation. And again, much too detailed to go into the specifics of relocation, but this is where you want to go back to the best interest of the child. The average relocation application that I see, regardless of what side I'm on, is usually for the benefit of the parent and not much of a benefit to the child. So that's a good way to attack it. And if you're the one looking to relocate, it's a good way you need to know to plan better so that you get the permission. Religion used to be the parent of primary residence was the person who made the decision for religion, but now I think the courts are taking recognition that they really can't step onto religious ideas, so that the parent who has the child for that time, that day, that afternoon, that weekend, gets to control what religion. So in many cases now, you're having children raised with both religions because the court can't stop one parent from teaching his or her child religion. Like I said, this equal footing now, we're starting to take a more equal approach in, like I said, sharing religion, sharing physical time, parent of primary residence. There used to be what was called the tender years doctrine, which basically said a child of tender years, which was usually like under 3, was best served by being with his or her mother, or the child's best interest was served. That is still in the books, but it's pretty much gone. It used to be what dictated custody, but now, unfortunately, it's gone. We're looking more at an equal. One thing to always remember if you are the non-custodial parent is to seek what's called the right of first refusal. That's basically saying that if the other parent is not going to be with the child or children, then you should have the right to be with that child. No reason they should be left with a babysitter or a grandparent if you are able and willing to take custody. But if it's not in your agreement, then you don't get it. And the reason is, theoretically, when you have your child, you are the parent at that. That's why we call parenting time. Decades ago, we called it visitation. Now the recognition is you're parenting. So if you need a babysitter, you use a babysitter. You don't have to check with the other parent. But if you're going to be the non-custodial parent, even if you're the primary parent, you may want to have that right so that whenever somebody else is going to be with your child and you're free, you can have him or her. Effective relationship with the mother, not going to get into that. Potential alienation. Alienation is a very big buzzword, and it is obviously something that you want to protect against. But alienation really takes a very long time. It can't be accomplished overnight, and it can't be accomplished if you are actively engaged in the child's life. So no matter what efforts the other parent attempts to inflict and attempts to wedge into your relationship, as long as you make efforts to stay there, you won't have alienation. Okay, so if you're looking for custody or looking to change custody, certain things you should know that are likely to come up, certain terms you need to know first. Custody experts, whenever you're looking to change custody or if there's a custody dispute, even in an initial custody case, you may need an expert to determine what's best for the child because the court can't accept your testimony. Guardian ad litem is an attorney, or it's an individual, usually it's an attorney that's appointed by the court to represent the child's interest. If the two parents are fighting over what's best for the child, sometimes the courts believe a child should have his or her voice heard, and that's what a GAL is for. Therapy is often going to be something you need to consider. If you're in a custody dispute, it's often very helpful for the family to have some therapy. If you're going to be in a custody dispute, you might want to have a therapist helping the child through it. An in-camera interview, lastly, that's where the judge will meet and interview the child behind closed doors. Usually attorneys are not present. It usually is recorded, but it's to keep the child from having to be picking sides and talking in front of either parent. Child support. I'll just take a quick second, see what more we have to cover here so I know how much I need to move along. And I got a lot left. Okay, so I'm going to try pick up the pace a little bit so I don't have to keep you here very long. And let me put up everything on this slide so I can talk about it at one shot. All right, so the New Jersey child support guidelines are presumed to be the accurate way to measure child support. And it's essentially a mathematical calculation. You plug in numbers and it gives you a child support. And I'll tell you in a second some of the things that go in and don't go into it. It's not used, or you can deviate from it if your income levels are above, I think it's $187,000 of net income, which means after-tax income combined. You use the guidelines, and then you have to add to that number what's called a high income addition. If you have more than 6 children, you have to deviate. Extraordinary circumstances, you may have children with special needs, physical, mental, educational, that need to be accommodated, that cannot be by the ordinary guidelines. And if you have a child that is 18 or at college, the guidelines are presumed to be inaccurate or not the best way to do child support. And they instead, the statutes then say you should go to the custody factors that are in the statute for it. But in my practice, most of us, including judges, still use the guidelines because it's just the easiest way to calculate a child support. So let's take a look at what is in the support and how some of it's calculated. Again, I'm going to put all this up so that I can go a little faster for everybody. So there is a sole and shared parenting worksheet. The main difference is going to be based on the number of overnights that the non-custodial parent has. So if you have more than 2 overnights on average per week, that's average, so it doesn't have to be every week, then you are a shared parenting. If you have less than that, you're sole. The difference is it's going to be a calculation because you get a credit for overnights. It's one of the adjustments. The more overnight you have, the less child support you pay because you're absorbing more of the expenses, the needs, the food, the utilities, the clothing. You're absorbing more of that. And then if you have more, and at a certain point when you have 2 or more, it shifts an entirely different calculation because you're covering more of the expenses overall. What is included? Included is food, clothing, shelter, transportation, entertainment, personal products. Extracurricular activities, very important. Oh, let me get my pen here. Wish this would stay on. Extracurricular activities are included. So that means you do not pay for dance classes, karate, anything, summer camp, unless it's a daycare. Now you can, of course, and many people do agree to it, but know that it's not included. So when you pay child support, that's all you're supposed to pay. And unreimbursed medical, up to $250 per child per year, which means co-pays, medicines, vitamins, wellness visits are covered inside of child support. Now, one thing in here that I don't necessarily agree with, but I believe the statute, the guideline statute says it, is you're not required to buy food and clothes for the other parent, but you are still required to have them for your parenting time. But that's going to be kind of a case-by-case basis. Most people don't. Most send clothes for the overnights. But now what's not included is private school and college, extraordinary expenses, which are usually going to be anything over like $500 that wasn't agreed to, and unreimbursed medical over $250. That actually gets paid out of pocket. Some of the issues when you are trying to figure out the incomes for your child support, certain people need to have other considerations taken in. First thing to know about it is, people always ask me this, it is your gross income is what they compute. They don't look at your taxes. And it really doesn't make any difference unless you have a different withholdings than you should. Maybe some people increase it or decrease it for tax purposes, but they're going to look at your gross, so you might need to change your withholdings. Some people have sporadic income. Union employees that sometimes have long spurts during the year that they aren't employed. A lot of wealth managers and financial advisors have very low salaries and very large bonuses. Self-employment individuals have fluctuations. You can try to build these things into your guidelines. The best way is to pay directly and don't have it paid through wage execution if you have sporadic or if you're self-employed, and make some agreement to catch up on the times where you don't earn enough. Because if you're paying through court and you fall behind, you can run into issues where they suspend your licenses and things like that, which I think will be coming up in a minute. Yeah, so I won't get into that. But it's better to try to pay directly and have some kind of arrangement or agreement for those that have fluctuating income. If there's SSD and SSI, Social Security Disability, Social Security Income, SSD is counted for income in child support purposes. SSI is not. It's just important to know that if you are going in and that's an issue in your case. Tax exemptions, not really that significant that we go into. Doesn't necessarily affect the guidelines calculation itself. So in the spirit of saving you some time, I'm going to move on a little bit. Another thing that is counted is work-related daycare. Very important to remember, it's work-related. It doesn't mean if the non-custodial parents, at home and wants a nanny or wants the baby to be in daycare so he or she can search for a job, that's not necessarily work-related daycare, and it's not necessarily covered. You can agree to it, but it's not necessarily what's intended. And it doesn't cover child over 13 any longer. Now, also, and one thing to consider if you're going to be paying work-related daycare is to pay it outside of child support, because what happens is daycare ends and many people don't have the opportunity to go back to court. They don't think of it. Sometimes they don't even remember, and they're continuing to pay extra child support for a very, very long period of time, and you don't get it back. Child support cannot be modified backwards, retroactively modified. So if it doesn't stop, it doesn't go back. So I usually recommend that you keep it out of child support. College contribution is separate from child support. It's important to know if you are paying child support and your child's going to college, you still may pay college contributions. If you're paying college contribution, it doesn't mean you get out of alimony, although it will usually lead for a modification. If you're paying college, especially if the child's living away at college, they issue the two homes, a college home and a home is going to be evaluated. And imputed income, which I think we've talked about enough. I don't need to touch on it there. We're slightly over my hour time, but I'm going to move on, not too much more. A little more on child support. Let's talk about the enforcements and the sanctions. First is it's preferred by law that you pay through wage garnishment. I'm not usually a big fan of having my clients pay through wage garnishment if I don't need to. One, if you do lose your job or you have sporadic income, the enforcement, which we'll talk about in a second, can be serious and greatly affect your life. You also will receive, or likely to receive, bi- or tri-annual cost of living increases. So your support will automatically be increased if you're paying through a wage garnishment or a wage execution, and you wouldn't have that modification if you paid directly. They can't even go back and ask for it on that basis. It's just not enough. Now let's talk some of the sanctions. If you owe child support arrears, they will intercept your tax refund. They can suspend your license. I think if it's over $5,000. Same with passport revocation. It will be reported to credit bureaus, and that's devastating because it often doesn't come off even when you do catch it up because of the nature of the credit reporting. And in some cases, they can issue a bench warrant for your arrest. A bench warrant means they can go and pick you up from wherever you are and take you to jail. And usually your bail will be set as a portion, usually 10% of what your outstanding child support is. So if you are falling into arrears, you should know that be ready that it's kind of hit or miss whether they go and try to pick you up. But if they pick you up, you need to be ready to pay bail. All right, let's talk a little bit about modification. It's going to be a lot similar to alimony, but there's one or two unique things. First of all, like I said before, cost of living adjustments is not a reason to seek modification. So if you've been receiving child support for years without the COLA adjustment, you cannot go to court and ask for it. If you're settling a case on child support, whether it's divorce or just through unmarried parents, you can agree to a cost of living adjustments in any kind of child support. You can also refuse to. Modification, again, changes of income needs to be substantial change in income and a permanent one. Changes to the children's expenses, again, the medical, educational, special needs, even in cases where children have special abilities. I've seen courts order an increase in child support to compensate and allow for these new skills or activities. Birth of a new child, like I said, the other dependent deduction. Emancipation of a child, which is when one child is considered to be of legal age or an adult. And then lastly, if a child goes to college, the presumptions guidelines don't apply, so you can use that as a basis to seek a modification of support, although you may often find yourself back in the circumstance of using the guidelines because it's just a lot easier. That looks like all the information that we have, so let's see if we have any questions that were posted or if anybody posted any questions going forward. I'm not seeing any just yet. So I don't know if that's good or bad. I don't know if that means I just answer our best questions or nobody's that interested. So, but put them up if you have questions. Like I said, nobody can see your question. I don't think anybody can see your questions or your name. So It's complete privacy. Let me know if there's any questions you have that I haven't touched on. Okay, I'm not seeing any questions. If you come up with questions after we disconnect, you can certainly email them to me. Here is all my contact information there, and I think here's a little broader for you to see it. Oh, no, I do see a question now. Okay. Will alimony stop if a spouse remarries? It's a good question. Most people think yes, but there's a little bit of an ambiguity that's been coming up in the case law. The statute says that remarriage terminates alimony, but the majority of people agree to alimony in a settlement agreement and not through a decision. So they'll say it stops consistent with the law, or they'll say, it terminates for these reasons. But if it doesn't actually say remarriage, it won't. And it's important because a lot of agreements say, well, it changes according to what the law says, because it's a lot easier. People think or they'll just say, it changes at death and think that the statute governs it. And the cases recently have been saying the statute doesn't govern your agreements unless your agreement specifically says the statute or the agreement is governed by the statute. So you need to specify. And if your agreement doesn't say it, then what the courts have been doing is having a hearing to determine what the intention was at the time you formed the agreement. Did you intend for remarriage to be a reason for termination? Did you intend to have the statute control in the absence of that language? So the easiest way is to put it into your settlement agreements. If you are going to a trial and a court's making the decision, then the statute will control and remarriage will terminate the alimony obligation. Next says, what about premarital assets wife keeps bringing? I'm not sure what that means. What do you mean about premarital assets? Do they affect the alimony obligation and alimony analysis? Could you be a little more specific? Okay. Your attempt to specify doesn't really give me a lot more information. I'm going to answer the question I think that you're asking, and if I'm wrong, just type another one up. I think you're asking, will the existence of premarital assets affect alimony? It's going to partly depend on what they are and who has them. If the average case, it's not going to, because premarital assets and equitable distribution or alimony and distribution of assets and debts are generally separate topics. Although the alimony statute does allow a court to consider equitable distribution of assets, but they generally do not. And the reason they don't is that the asset distribution, or the assets that you leave a marriage with, premarital or marital, don't usually do so much to change your income level. Now, if you're in a higher income level or you have substantial assets, whether they're premarital or not, and they are generating moderate to substantial interest income or investment income, then they will be considered, because the investment income or the interest income will go to that party's needs or lack of need. So premarital assets or marital assets will only affect alimony if the interest or the income derived from them affects the party's needs. And let me know if that answers your question. Another question: if one spouse moves to a non-alimony state and then files for divorce. Okay, the question was cut off for me for a second, so give me 1 second. One spouse moves to a non-alimony spouse, then files for divorce. What are some of the non-alimony states? What if a spouse is living separately in different states for 12 months and then files? All right, so we have a number of different questions. I'll break them down for you to the extent that I can. What if one spouse moves to a non-alimony state and then files for divorce? It's an interesting question. A couple things may happen. And it's going to depend on many factors. I can't really go that deep in this question, but I'll try my best. If you move into another state and you qualify to file for a divorce in that state, you will generally be governed by that state's laws. However, there is a law that's called the conflicts of law that says even though you're in one physical state, that state may be required to use the law of another state to determine its issues. And that conflicts of law is what is intended to cover a situation like this, where if you had a 20-year marriage in New Jersey and you had children and doctors and witnesses and assets and credit cards and all from life in New Jersey for 20 years, and then you move to California for 1 year and you file there, California may have jurisdiction. They may not, but let's say they do have jurisdiction over the divorce because you live there. But New Jersey law should really be used to govern the decisions that are made about the distribution of assets and debts in custody. So the California court could be petitioned to use New Jersey law even though you're in their courts. Second question is, what are some of the non-alimony states? I don't know. I don't know of any states that actually have no alimony, but many states will have different laws about alimony. There could be some that don't have it. I really don't know. I concentrate solely in New Jersey now. What if spouses are living separate in different states for 12 months and then one files for divorce? Well, the separation is not going to make much of a difference in how the law is applied to the case because 1 year is not significant. That 1 year hiatus, though, can affect a lot of decisions like alimony and custody, because if one party is living for 12 months separate and doesn't need support from the other parent, it shows that they don't need support. And you can make an argument that that person doesn't need alimony because they've lived a year without it. Conversely, if that person has had the child for that year and there's been sporadic or non-existent parenting time, you can then argue the other parent shouldn't have that much parenting time right now because the child needs to adjust to the parent who's been absent for that year. So it can complicate a lot of issues. And I generally tell people, don't do it. A lot of people will separate for years and they think they're doing themselves a benefit by staying together. And it's not. It's just complicating the issues that probably could have otherwise been resolved a lot more simply. I hope that answers your question. If it doesn't, just post more up. I don't see any other questions, but I'll hang out for another minute or two just to make sure I get them all. Anybody? Going once, going twice. Oh, okay. Right under the gun. We got a couple. Okay, good. Is 12 months a good time to separate? Do you mean, is it good to stay separated for 12 months? I'm going to give you a second to kind of revise. I'm not sure if you're asking, is it good to separate after 12 months or is it good to be separated for 12 months? Do you want to file after 12 months? So if you could just tell me a little bit more what you're trying to get at there. So I have another question. I'm not sure if it's a question. It says, wife went to law school while husband sat home taking care of the kids. Well, there's a lot of issues that can come up in this circumstance depending on which party you are to this. This will raise, first of all, alimony. If the husband sat at home taking care of the kids, then he is the economically disadvantaged spouse. Alimony is intended to compensate a person who's made these kinds of sacrifices. I'm not sure if you got the earlier part of this, but it's usually the non-financial contribution that allows for alimony. So the husband in your circumstance would be an alimony candidate. One form of alimony that we didn't talk about is also called reimbursement alimony, which is separate from a need-based alimony, which is your most common. Most of the alimony that we talk about in this and other webinars are need-based. Rehabilitation, or not, reimbursement alimony, it's called. Reimbursement alimony is for one spouse that contributed to the other spouse's acquisition of an asset, like usually it's a professional degree or any degree. One spouse either stayed at home and take care of the kids or financially contributed to the other spouse's acquisition of a graduate degree or professional license. Now that parent or that party has an income generating asset, an advanced degree, you earn more money. So you can receive reimbursement alimony just for that contribution alone, aside from your need-based alimony. Not very common, but it does exist. Now I see there's a tail end to that question. It says, now she wants to file divorce, husband initially paid for fee. So I hope I answered your question in that, because it would entitle the husband to both a need-based alimony and a reimbursement-based alimony. Now the other individuals revised this question, meaning if separated for 12 months and each taking care of themselves, it's a good argument not to pay alimony. Yes. It's a good argument because you could argue that they didn't need it. They could have filed for divorce or support in that year and didn't. So it does suggest, or does help suggest, that they don't have a need. It's not determinative, because they may have been living under the lifestyle that they shared. They might have not been able to file for it, but yes, it certainly would make the argument more compelling. There's no saying he was taking care of 12 months. So that's reset. Yes. Okay, so I think I got the questions that were just posed. It came in a little bit of piecemeal, so hopefully I put them together for you to answer them right. Like I said, let me know if there's other questions. I'm here as long as you need. All right, once again, going once, going twice. Right, so next, I'm sorry to say, I don't know what our next webinar is going to be. I forget the topic, but it is posted on our website, micklinlawgroup.com, MICKLIN, lawgroup.com. Should have the date, the topic, and a link for registration. It'll be, I think, the last Thursday of next month. If there's something that comes up after I sign off that you didn't get to ask, feel free to send me an email. Call me in the office, 973-562-0100. Otherwise, I wish you a good night, and I hope you all have a great holiday weekend.